The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Be seated. Welcome to the Fourth Circuit. We have three cases this morning for argument. And we'll proceed with U.S. v. Kennedy. Mr. Ryder Longmaid, whenever you're ready.
Thank you, Your Honor. May it please the court, Parker Ryder Longmaid for defendant appellant Jermaine Kennedy. Trial counsel's failure to object to the reinstatement of Mr. Kennedy's career offender enhanced sentence after this court's intervening change in law in United States v. McCollum was ineffective assistance of counsel. I want to just briefly summarize why, and then unless the court has questions on that issue, explain why competent counsel would have known that the mandate rule would not have been an impediment here. McCollum made clear for the first time in this circuit that the categorical approach applies to conspiracy offenses under guidelines sections 4B1.1 and 4B1.2, and that conspiring takes its contemporary meaning rather than its common law meaning, and further requires an overt act, such that any conspiracy offense that does not require an overt act cannot serve as a...
But McCollum didn't address an 846 conviction, which was at issue here. That didn't occur until 2019 in Norman, correct? So how does that impact your argument?
That's right, Your Honor. But what Norman makes clear is that even though there was not plain error, it was a straightforward application of McCollum and the McCollum controls. I think the only question in Norman was whether there was some confusion from the court's 1994 decision in the United States versus Kennedy. And I think what is also clear from decisions like this court's decision in United States versus Carthorne in 2017 is that the plain error standard and the ineffective assistance of counsel standard are two different things. The real question here is whether defense counsel should have known that there was a viable argument that could have secured relief for her client. And the only issue, the main issue, but probably the only issue, when the case came back down from the government's appeal in April of 20...
Can we go back to a little bit before we even get to whether there should have been an objection? Why was resentencing even an issue? Why wasn't appellant's original conviction and sentence just not automatically reinstated upon reversal by us?
Well, Your Honor, of course, the court's, there was no operative sentence because it had been vacated by the district judge before it went up. And the case came back down. There was no specific remand. There was no limited remand. The court just said further proceedings consistent with this disposition. And so some action had to be taken. I think as even the government says, they say it's administrative. But at that point, the real question would have been, what a competent defense lawyer would have done at that point and said, is there any reason this sentence should not be reinstated? So even if there was some question about whether the mandate rule applied, then I think the easiest way to look at this and the narrowest way to look at this is to say, okay, does an exception to the mandate rule apply? If we want to talk about United States versus Carthorne and the ineffective assistance of counsel standard, what would have been counsel's duty at that time in May of 2018 when the government wanted to reinstate this sentence? Well, she should have thought, okay, is there any way I can prevent reimposition of this sentence? Because if you know what the law is, I've read McCollum, I can see the straightforward analysis. What could I argue? Well, this is a change in controlling law. This is a dramatic change in precedent. I just want to walk through the three things that McCollum does because I think the Kennedy issue is a little bit of a distraction. The three things that McCollum does, it first says, none of these things have been held by this court before. We're going to apply the categorical approach to conspiring under the guidelines, sections 4B1.1 and 4B1.2 for the career offender predicate. Now, Your Honor is right, that was in the crime of violence context in McCollum, but of course, application note 1 to section 4B1.2, it's the same language. It says, I believe it says something like crimes of violence and controlled substance offenses include conspiring to do those offenses. It's the same exact guideline. You would also point out that McCollum actually cites Martinez-Cruz, the 10th Circuit decision, which looked at section 846 conspiracy specifically. I believe that's page 308 at note 6. So the tools were there. The next thing that McCollum says is we're going to, when we're applying the categorical approach, look at the contemporary meaning of conspiracy. And there's a dissent on each of these points, right? Look at the contemporary meaning, and then when you look at the contemporary meaning, say there's an overt act requirement. And when I say there's a dissent on each of these points, it shows that this was a change in the way that the court was thinking about these issues. Because on the first question, Judge Wilkinson's dissent in McCollum, he says, you shouldn't even apply the categorical approach here. This is just a plain text reading. If you conspire to do something that is a controlled substance offense, you have committed a controlled substance offense. He said, wouldn't even apply the categorical approach. Strong dissent on that point. The majority says no. Then he goes and says, okay, even if that's wrong, he says in dissent, you shouldn't be looking at the contemporary meaning, you should be looking at the common law meaning. This court had a decision in 2015, Etienne versus Lynch, it was the Immigration and Nationality Act context, looked at common law meaning instead of contemporary meaning. And at common law, there was no overt act requirement for conspiracy. And then Judge Wilkinson also says in his dissent, even if you're going to look at the contemporary meaning, you should do what the Fifth Circuit said in Pascasio Rodriguez in, I believe it was 2014 or 2015, where he said, where the Fifth Circuit looked at this and said, we know that there are more than 30 states that don't require an overt act, but we've looked at the federal, that do require an overt act, but we've looked at the federal conspiracy statutes, and I think it's 142 of them by the Fifth Circuit's count that did not require an overt act, and only 24 that did. So they said, we think that federal law is more important in this context with all the federal conspiracy statutes. We come to a different conclusion. So these are three steps that are very important that lead the court to the place where it says, the governing rule, but rules to get to that place, you have to ask whether there's an overt act requirement for any particular conspiracy offense to trigger that enhancement. So I think at that point, Your Honor's question about Norman, this is just, as Norman itself said, a straightforward application of the rule in McCollum.
And how do we know that the lawyer in this case didn't do what you just described?
Well, I would say two things. I would say there is no evidence that she did, but I think even if she...
Absent any evidence, why wouldn't we simply, if we agreed with you, simply send it back and ask?
Well, I think you could do that, Your Honor, but I don't think you need to for the reason that we explained in the brief, which is that what the lawyer does has to be reasonable and informed by reasonable professional judgment. As we've explained, it's not reasonable to look at McCollum and just not make that argument.
Well, certainly not in a vacuum, but we don't know what counsel below was thinking. Perhaps there's something lurking in the back that we just don't know about that might be adverse to your client in a full plenary resentencing hearing. So that's my question, is maybe the lawyer, maybe you're right, maybe this just went right over counsel. He had no inkling about the change in the law, but on the other hand, maybe he did and decided for whatever reason that this wasn't, that the defendant was better off where he was in terms of his sentence.
Well, Your Honor, a couple of things. We can look at the only evidence in the record here, which is the affidavit from Mr. Kennedy. This is at J313. And he says defense counsel visited him in prison and conveyed to him that there was no need for the affiant, Mr. Kennedy, to have a formal resentencing hearing whereby his appearance was required.
Well, that's one version of the story, right?
Certainly, Your Honor. But and if the court would want to send it back for development, that's certainly an approach the court could take. But I think the point that I'm making, Your Honor, is that this is a career offender enhancement which triples the guidelines range. This is a really draconian enhancement. You have the sentencing record before Judge Bennett where he goes through and he explains why he's giving the sentence he's giving, which is the sentence he gives, yes, it's under the career offender range, but it's twice what the range should have been. It's twice what the top of the correct guidelines range should have been. And what he primarily talks about is Mr. Kennedy's prior offenses. And he says the guidelines range is a factor, and that's JA-179. And when he goes through, again, in the 2255 motion, what he says is the guidelines, he says that the sentence was not entirely based on the guidelines range. Well, that is the point there, is that the sentence was based, at least to some extent, on this guidelines range. And Mr. Kennedy got 4 or 5 years higher than the next closest defendant because of this career offender history and these prior convictions.
Does the timing have any bearing? As I understand it, McCollum was decided 2 weeks before a mandate was issued, and then the lawyer for Kennedy, after the mandate was issued, consented to the reinstatement of the judgment. So whoever the lawyer was obviously had time to be made aware of McCollum, right?
Judge Floyd, I think that's exactly right. So the court issues this decision on the government's appeal in Mr. Kennedy's case on March 9th of 2018. The court decides McCollum March 20th of 2018. The mandate issues April 2nd of 2018. The government files this resentencing, its reimposition of sentence motion on May 9th, and the court then reimposes the sentence on May 10th. So
Is there any restrictive language in the mandate that would prohibit Judge Bennett from looking at the sentence?
there's nothing, Your Honor. It's just a general remand. It says further proceedings consistent with this disposition. So what you have, we've explained this two ways in the brief, and I think conceptually you can look at it either way. You can either look at it as the mandate rule doesn't apply, or even assuming the mandate rule applies, there is a well-established exception to the mandate rule for a change in controlling law. And I can explain how you can get to the same place on those. But what we have facing defense counsel is there's no operative conviction and sentence because Judge Bennett.
What do you think would be the preferred way to do it? The mandate rule doesn't apply, or there's an exception to the mandate rule, from your viewpoint?
So, Your Honor, I not to be presumptuous, but if I were thinking about how to draft an opinion, I probably would use the mandate rule exception because it's a narrower way to approach the case, and I think much of the government's brief talks about counter arguments it has to looking at this as a mandate rule issue. This is a very unusual case. We did a lot of research about this type of case. How often does a district court grant a Brady motion, a new trial motion under Brady in the first place? Wipe out the sentence, it goes up to the Court of Appeals, the Court of Appeals reverses it. Probably very few cases where the district court grants a Brady motion, probably even fewer where the Court of Appeals reverses it. So you have this very rare circumstance. If you're worried about floodgates, I don't think there are.
And then in the interim, there's this case law that would radically reduce the sentence.
That's right, Your Honor. And so I think even if you approach this under the concept that the mandate rule doesn't apply, let me just see if I can explain why it would be that way, but I think conceptually it gets to the same place as why there's an exception to the mandate rule. We point to three things, and all three things we think are true here and matter, and you don't have to decide the case based on any one of the things. The first thing is that the conviction and sentence are wiped out by Judge Bennett when he grants the Brady motion. The second thing is a general remand language. It goes to Judge Floyd's question. It's not a limited remand. The Court of Appeals didn't say we're sending this back with instructions to reinstate the sentence. If it had, then maybe we could only rely on the exception because one could make the argument, the government could make the argument in that circumstance that there was the mandate rule did apply. And the third piece is that, of course, as Your Honor said, McCollum didn't come out until the case was on its way back down from the Court of Appeals. So that's a change in law. So whether you view that as there was no opportunity to make this McCollum-based objection before then, and because the mandate rule, of course, applies to issues that were decided by the higher court, Supreme Court, Court of Appeals, in the case, or to issues that could have been decided and they were forfeited or waived. And as we explained, that wasn't the case because of the sea change in McCollum, and those objections, you wouldn't have forfeited those objections based on a case that hadn't been decided yet. But I do think the easiest way to write an opinion, if the court is so inclined, is just to say, even assuming that the government is correct, that the mandate rule applies, in this circumstance, McCollum was such an important change in law, the defense counsel was derelict in her duty not to understand the implications of McCollum and make an argument that had a real chance, real fighting chance for her client. And I think I would just make a couple points on prejudice because I don't actually think the prejudice is a hard question. Of course, you have to prove deficient performance and also prejudice. As I said, there's a very strong presumption. The Supreme Court has repeatedly instructed, most recently Rosales-Morales in 2018, I believe, or more recently in Molina-Martinez in 2016. It's a presumption, which means the government has to show it doesn't apply, that if there's an error in the guidelines range, and the correct guidelines range would be lower than the guidelines range that the court used, then you presume that there's prejudice. And I would just point out here that in addition to the fact that the court said the career offender status was a factor, we also have the court saying at JA 172, acknowledging that the guidelines range is a starting point in the analysis. And of course, the basis, one of the key bases for the Supreme Court's case law, it's an anchor, it's a starting point. It's where you expect district judges to start. And then he says later, he comes back and he says, you face this exorbitant amount of time just because of you qualify as a career offender. So I think it's impossible to say that there's not a reasonable probability of a lower sentence. If the guidelines calculation had been done correctly, it would have reduced by 2/3 what the correct guidelines range was. And the last point I would say about this is the government's theory seems to rely on this proportionality notion that Judge Bennett said, I have these multiple co-defendants, I want to sentence Mr. Kennedy proportionally with the others. I would just pick two.
And the original sentence was a below guideline sentence. So even on resentencing, if the court wanted to impose the same sentence, it would have to depart upward from the new guidelines.
That's right. That's right, Your Honor.
Wildly disproportionate.
That's correct, Your Honor. And of course, the Supreme Court makes clear it doesn't the presumption doesn't turn on where the actual sentence was given. It's just to defeat the Supreme Court's presumption, and the government does cite some pre-Molina Martinez case law, there'd have to be a very clear statement from the district judge saying, okay, I've calculated the guidelines, but I don't care what the guidelines say. I'm going 3553A all the way down, and here's why, and it doesn't matter if I get reversed. I mean, there are examples from the courts of appeals where not, I don't think in this circuit, but where district judges have said that, and they've managed to survive that kind of review. There's nothing like that here. And in fact, Judge Bennett says, in light of Washington getting 12 years, in light of Parker getting 121 months or 10 years, I would just point out that Washington was also sentenced as a career offender. He would not have been sentenced as a career offender for the same reasons Mr. Kennedy would not have been sentenced as a career offender, so that drops out. And then Parker's had one serious prior conviction, but it was a bank robbery with a firearm. So if you're trying to compare the severity of the criminal history, you can't look at this and say Judge Bennett was not concerned about the career offender enhancement. It was only concerned about the underlying convictions.
Thank you, counsel. Mr. Moore?
Good morning, Your Honors, and may it please the Court. Brandon Moore on behalf of the United States. Rules matter, and here the mandate rule would have barred a McCollum objection on remand. Kennedy 1 corrected one error, and McCollum wasn't controlling or dramatic enough to revisit anything else, given the published, binding cases that had all said that 846 was a career offender predicate. And against that backdrop, Mr. Kennedy's counsel did exactly what she was supposed to do. She considered the mandate rule and applied it correctly, or at least that's what the evidence shows thus far.
How do we know that?
We know that, Your Honor, from Mr. Kennedy's affidavit. There he says, as my friend on the other side had said, that at some point, at least his version of the story is that at some point she had visited him in prison and said that there were no, quote-unquote, extenuating circumstances. That, Your Honor, tracks with the exceptional circumstances language in Bell that triggers the...
If there were extenuating circumstances, McCollum had been decided.
McCollum had been decided, Your Honor, but as we all pointed on the other side, there were a couple of issues with it. The first was that it was about a completely different offense. We're talking about a 922G, even though it was under the same guideline provision, 4B1.2. And then the other issue is that it's concerning a racketeering conspiracy, a crime of violence, whereas this is something different. This is a drug conspiracy. So what you're asking Mr. Kennedy's attorney to do at that point is to take the logic from a case that could apply and then try to trumpet that up in the face of
Just what attorneys do. That objection would not have been frivolous, would it?
It's a possibility that it wouldn't have been. And then the reason why I say that...
What's the downside? It just seems to me that other than having to do a little bit more work, she might not have succeeded, but she might have. It just strikes me as really odd that the lawyer simply would just say, well, never mind, I'm not even going to try.
And I have 3 points to that. The first is I do want to make clear that I think there's some recognition that there's the mandate rule there. And the cases at the time are supporting her thinking, where they're all saying, okay, we have McCollum, but it doesn't discuss Kennedy or these other cases. It makes it more murkier, then it makes it more authoritative or decisive. The second thing is there is a cost. I grant you that it is not as significant as the guidelines changing, but there is a cost. Because at this point, Mr. Kennedy has not yet had his direct appeal. The appeal was already paused for the sake of going up and looking at the tally sheet. It's back. There's a limited remand on that issue. And so you have to make the calculation. The issue he actually brings up on direct appeal is actually quite significant. He argued the multiple conspiracy issue. That was significant enough to trigger oral argument and a published opinion.
How are those two mutually, they're not mutually exclusive, are they? You can object and then appeal.
Well, they are not mutually exclusive, but I think this gets into the weeds of the sound trial strategy, because the multiple conspiracy argument, which she can lodge on appeal, is one that would actually eliminate the conviction and sentence if he's able to go pursue that. On our record, she's making the calculation that she could object to this, but she will likely lose and stall getting to the one issue they can raise that could potentially eliminate the conviction and sentence. And so based on our record, that's a reasonable strategy because, again, we cited cases in the Fourth Circuit saying that, well, we do have McCollum, and Whitley at that point when we're getting to the Fourth Circuit cases. But that's muddling things. That's not enough to trigger the exception under Bell. And then the second thing is I cited 2 District Court of Maryland cases. People are lodging straightforward McCollum objections at sentencing. And so if you're, and they're losing in these cases, they're saying, I see what you're saying about McCollum, but as far as I'm concerned, Kennedy controls. And so this is the analysis that she's doing at the time based on.
Well, you're painting a picture, and that, you know, that may or may not be compelling. The problem is we don't have that picture in the record. You're making a number of assumptions, I think, some of which might be reasonable, but some suggests pure speculation as to what the lawyer was thinking about.
And to your point on opening, Judge Diaz, I think at bottom, this doesn't require a whole-scale reversal and resentencing. I think this requires a chance to just at least hear from her and what her thinking was. Because, quite frankly, there's 2 parts to this. The one piece of evidence that we have is that she is thinking about the mandate rule, and it's reasonable to think that she can conclude that way at the time, and it's reasonable in light of the case law controlling mandate rule,
What
period.
would she have concluded about the mandate rule, in your view?
She would have concluded that even if McCollum had been there, it would not have been controlling or dramatically changing enough to be able to overcome the mandate.
So that there wasn't an exception to the mandate rule?
That is correct. And then the other component to that is kind of collapsed into the prejudice, right? Because we have what I believe is a very robust sentencing transcript that makes very clear that although the career offender guidelines did apply, it did not have the relevant, meaningful impact on the sentence such that you could conclude that if the guidelines were different, that he would reach any other different sentence. And
Well, wait, didn't the district court sentence Mr. Kennedy to 192 months?
that's correct, Your Honor.
Which was below the guidelines, the 262 to 327 months, correct?
That's right, Your
The
Honor.
new guidelines would be 77 to 96 months, correct?
That's right, Your Honor.
So if he wanted to impose the same sentence, he would have to not downward depart, but upward depart to 192 months. How is that not a significant change and difference in the way the district court may have been thinking?
Sure, there are a variety of factors
And
at
prejudicial.
Absolutely, Your Honor. There are a variety of factors at play. I think the first is we can look at the record as to what he said. The first thing he says is
By he, you mean the district court?
the district court, yes, Your Honor, I apologize. We can first look at what the district judge said. The first thing is he comes out 4 times and he says the career offender guidelines are not reasonable. 4 different times. And I think that's important for one reason. And the fact is, we only know that the guideline range is 77 to 96 months because the district court told us. We walk into the sentencing hearing that day believing that there's a certain drug amount weight that's there that triggers the 848, the 851 enhancements, right? If it weren't for the district judge not believing that the evidence at trial warrants something not even 20 years and scrutinizing the government's evidence, Mr. Kennedy's not walking out of there without a 20-year sentence to begin with. The district judge is the one who both triggers those 77 to 96 months and breaks for lunch, makes probation go calculate, and then comes back and says, government, this is the range at the bottom, this is the range with the career offender guidelines, let's go to the 3553A factors. So he's aware of both of those ranges. The second thing he says is, having eliminated the 20-year mandatory minimum, he tells us 2 things. 1, that's a fallacy, and 2, they're mercifully gone. Mr. Kennedy doesn't even deserve that. So we know 20 years is out of the question for the district judge. And then we also know that the career offender guidelines are out of the question because he tells us 4 different times. He then notes that Mr. Kennedy was in federal court for the 3rd time. He said that Mr. Kennedy was on 2 separate terms of supervised release. And he said, as we all agree now, that the most important factor was the sentencing disparities. And, Your Honor, I was thinking about this a lot leading up to argument. I think there's what we read in the record, and I think there's what the record says. And I think it's really important to place context as to when the sentencing had happened. Most, if not all, of the defendants were sentenced within 3 months of this 9-day jury trial. The district judge is hearing all of this evidence. He's very familiar with all of these defendants are. And I point out to you that he starts the sentencing hearing by ticking off the defendants who he had just sentenced and telling the parties, this is what I did, this is what I did, this is what I did. He corrects the government on what the evidence showed at trial, what happened at trial, what happened at these other sentencing hearings. And even Mr. Kennedy's lawyer says, hey, I went to Mr. Agnon's sentencing hearing just last week. And it's because his counsel knows that it's more important what everybody else gets leading up to Mr. Kennedy's sentence than the career offender guidelines. They're sentenced as a package. And all three people involved, three parties, I should say, the government, Mr. Kennedy's defense counsel at the time, and the district judge, their main arguments are, this is the offense, this is how everybody fits in. They're all sentenced closely related in time. You're keeping track of what everybody else gets, and they're trying to figure out where everybody fits. The government says twice that the guidelines are irrelevant to them. They don't even bother with that. They think that where Mr. Kennedy fits in with everybody else is somewhere at the top. Mr. Kennedy's lawyer, just having sat in on somebody else's sentencing hearing trying to get a sense of where he fits in, says, hey, on the one hand, this is a very serious offense, but it's not as serious as these two guys. But I recognize that for Mr. Parker, who's in the car with him, he has a more significant sentence. So that's the range. That's the range that Mr. Kennedy's counsel comes up with. Something in the middle of these 9 defendants. That is the driving factor. And when we talk about why specifically 192 months, why? If I may, I want to read this statement from the district court. It says, JA 179, according to my calculations, 192 months comes out to 16 years in this case. It's greater than some of your co-defendants because your record is more severe, but there has to be some proportionality to it. And in light of Washington getting 12 years, and Agnot getting 10 years, and Sampson getting 8 years, and Parker getting 10 years, I think that's a little bit more proportionate of a sentence. That doesn't change if the guidelines change. That is the district judge telling us exactly where Mr. Kennedy at that time fits in with everybody else. And then this is what puts this, I want to make clear, on entirely different footing than the cases where we see guidelines prejudice. I'm talking about Freeman, I'm talking about Carthorne, cases where either the parties, and I apologize, maybe not Freeman, but specifically Carthorne, cases where the parties are coming in either with a guidelines recommendation, it's very clear that it's tied to that, or if there's such a disparate sentence and the judge says absolutely nothing, just has the career offender guidelines, and then it appears as though he just gives something either above or below or within that. This is completely different. Not only are the statements within the sentencing transcript supportive of the fact that he gave a specific sentence, but it's also just the circumstances, the surrounding circumstances of the sentencing itself, and then the steps that people took heading into the sentencing. And then I can even break it down even further. I think one of the even more telling statements that the district court makes is that your criminal history is worse, but that doesn't justify more than 5 years than Antoine Washington. And then lo and behold, he gives them within 5 years of Antoine Washington. I think if you have a district judge who comes in, eliminates the mandatory minimums, tells you what the other guidelines are, and then eschews, says 4 times that the career offender guidelines are unreasonable. That's not a district judge who's putting significant enough weight on that to then say that the guidelines.
Well, but he doesn't completely eliminate. I mean, he says throughout that they are, there are factors. So that's the problem we have here.
I don't think
Not a problem. I mean, it's entirely appropriate. He's supposed to.
Which is what my response was going to be, Judge Diaz. The problem I think Mr. Kennedy has is that if he says nothing about the guidelines, that's a Booker problem. Booker requires him to correctly calculate the guidelines, which he does. It also requires him to consider them, which he has to do. And then that's precisely what he did. I think that's what he does at the front end when he concludes after his calculations that Mr. Kennedy is a career offender. That's the conversation that he's having with Mr. Kennedy's counsel when he's going through his recommendation for a sentence. He stops him and says, counsel, your client's a career offender. Does that put him on a different footing? It's not to suggest that the career offender is the end-all be-all. That's the logical response to putting Mr. Kennedy in the middle. He's saying, your client, I understand, also has a more significant criminal record than many other people. And the fact of the criminal record puts him on different footing, not necessarily as a career offender. And then at the end, I would say in his opinion on the 2255, he says, the career offender is not the only factor I considered, which is true, but he's saying that not because to signal that the career offender was, one of the two, but that it's one of the constitutionally required things that he's supposed to consider. If he doesn't say career offender, we'd be back here on that instead. And if it's just the mere fact that we mention the word career offender, then that's every single case. That would eliminate cases like Molina-Martinez, which stand for the fact that it's not just the fact that the guidelines change, but that we can point to areas in the record to assuage ourselves of concerns that was the thing that would have affected and caused prejudice. If I may, I want to go back just to one point on the general remand interplay that we had in the opening. The two things I want to say is that the remand language from Kennedy 1, it was general, but I think it would circumvent precedent to just say that because it was general, that means everything is up for grabs. And on that point, I point Your Honor's attention to Pileggi and Soucy. I think theoretically, or I think legally, what those stand for is the fact that when we're looking at the remand language, even if it is general, we're not just carrying out the letter of the remand, we're carrying out the spirit. We look at the circumstances of the opinion in the case. There was one issue raised, one issue corrected, it came back, and we were limited to just that issue on review, unless, of course, exceptional circumstances existed. The second thing is this idea that there was no operative sentence. And technically that's true. We had to move to reinstate the judgment in the sentence. But the idea that these things substantively fall away just because we corrected an error that was procedurally before that just is not supported by case law, and it's just not workable. And again, I point Your Honors to Pileggi and Soucy. Pileggi says when you remand to fix the length of imprisonment, the restitution order doesn't just, the restitution order just doesn't disappear, you put it back. Soucy says when you go back to fix a 3553A error, the previous guidelines don't disappear, you put those back. Those cases stand for the proposition to where if you fix your error and it doesn't require you to fix anything else, you leave those things alone unless there's a reason to do so. That triggers the exceptions in Bell. The second thing, as I said, is that it's unworkable. And that, take for example, Judge Bennett had erroneously dismissed the indictment. If that comes back on remand, there's no expectation that this leaves the initial appearance up for grabs, the detention hearing, motions hearing, trial, sentencings. There's none of that. We go back to the point in time where the error happened, we fixed it, and then we move on. And so for those reasons, Your Honor.
Well, but in a case like that, I suppose one could say that if the issue isn't raised in the first instance with the district court, then we can make a distinction between issues that are waived or not. But here, there would have been no basis for making the McCollum argument because McCollum hadn't yet been decided.
On the front end, but that's why the exceptions, right? One of the exceptions is if there is a dramatic change in controlling law. And if that happened, say if McCollum were right on point, say if it's Norman, he would have a much stronger argument if it's Norman. That's right on point, it's a dramatic change. All of a sudden, he's no longer a career offender, right? Then you would start getting into that pocket. But here, this is not that case at all. This is McCollum. This is something else. This is a different offense, different underlying offense, different prior offense. And you have three binding precedent sitting there that it talks about not at all. And so you're making that kind of assessment. And quite frankly, Your Honor, the standard even contemplates that. It says you don't just get to go back and have a free swipe. You don't get the benefit of a rescue on remand to take a second chance at something that you did not come up the first go around. And so had the case been in different footing, he may be able to survive Bell in a different way, but in this particular circumstance, he didn't. And so for those reasons, I think that his counsel acted very reasonably and even thinking that the mandate rule applied, let alone concluding that it did based on the record that we have. And we have a substantial record at sentencing showing that his sentence would not have been any different absent the career offender guidelines. And so for those reasons, I respectfully ask that you affirm. Thank you.
Thank you, Mr. Moore. You have some rebuttal time, Mr. Rider-Longmaid. Go ahead.
Thank you, Judge Diaz. I want to just make a few points about prejudice and then a few points about the mandate rule exception. I don't think the government's argument can be squared with Molina Martinez and Strickland. We just have to have a reasonable probability of a different result. That's all that's required. Molina Martinez makes clear that the way that standard, that well-trod standard applies in the guidelines context is you have an erroneous guidelines calculation. There's a presumption, if the correct range would have been lower, that there's prejudice. And we know, as Your Honor also noted, that the guidelines were a factor. I want to read them from J179, where Judge Bennett says, you have been bumped up to a higher category because of being a career offender, so it is a factor here. That's all we need. One extra day in prison is prejudice. That's what the Supreme Court has said, Glover versus United States. So I don't think there's anything to the prejudice argument. If you want to talk about the proportionality principle, as I said, Washington was erroneously sentenced as a career offender. The same analysis would apply there. You can't have a proportional sentence to Washington if his sentence goes out the window, so I don't think any of that really works. About the other point I would make about prejudice is the government suggests that somehow these cases decided by the District of Maryland, which of course doesn't bind this court, or wouldn't bind another judge, or even the same judge in the District of Maryland. Even all that's beside the point, because when you look at prejudice, hindsight is 20/20. Not the case for deficient performance is the case for prejudice. Lockhart versus Fretwell. There are other cases also from this court that say that. Just to talk about the procedural posture of the case and the mandate rule exception. I hear most of the government's arguments being about whether the mandate rule applied in the first instance. We had a colloquy earlier about the best way to do this. I think you look at the exception. I don't hear a strong argument against applying the exception here because of McCollum's intervening change in the law. And I just want to say the government's argument seems to be that Kennedy was controlling precedent. And then it says McCollum muddied the waters and left it an open question. Even on the government's account, that's a change in controlling law. But I would say all you have to do is look at Norman 935 F 32, 39 to 40 to see the problems with reading Kennedy and the two other cases, which are Walton and Brandon, that the government points to here, to read those cases as controlling precedents. Just really quickly, this is what the court says in Norman, but of course, neither party addressed whether Section 846 conspiracy is a controlled substance offense in the Kennedy case. There were two holdings that revolved around 846, but one was just whether the Sentencing Commission had authority under Section 994 or another statute to make conspiracy offenses controlled substance offenses, and the other was a holding about whether the district court had authority to make factual findings about when a conspiracy began. Those are two different issues. In Walton, the question was about aiding and abetting and whether that qualified, which is not conspiracy here, and Brandon doesn't even mention Section 846 at all. So I think you would have a defense counsel who had read McCollum, straightforward analysis. I know it's not the exact same offense, but Judge Wilkinson's dissent says you're about to basically says you're about to open the floodgates because most federal conspiracy statutes do not require an overt act. I mean, that is a red flag right there for defense counsel to say, what about the conspiracy statute in our case? So if there are no further questions, I would ask the court to reverse the judgment of the district court and remand for resentencing without the erroneous guidelines offender enhancement.
All right. Thank you both for your fine arguments. We really appreciate your being here this morning. We would typically come down and greet counsel. We are not able to do that because of our COVID restrictions, but hope to do so in the future. Hope you'll come back so that we can do that. And Mr. Rider-Longmaid, I see that you are court appointed. I want to thank you for taking on the assignment. Both counsel did an excellent job here today. Mr. Rider-Longmaid, I don't think you came up for air once during that argument. I would simply, just a suggestion, you might want to try to slow down a little bit because you did a wonderful job, but I sometimes had difficulty keeping up with you. It may be that I didn't have enough caffeine this morning. But you leave here with our thanks for taking on this really interesting case, as does the government. Thank you both for your arguments. We'll move on to our second case. Our second case is JTH Tax LLC versus Shahabuddin. Ms. Saharia, whenever you're ready.
Good morning, and may it please the court. Amy Saharia of Williams & Connolly for Appellant Liberty Tax. The district court erred in granting summary judgment to defendant on both Liberty Tax's claim for breach of contract against the defendant and on the defendant's counterclaim for breach of contract against Liberty Tax. If I may, let me start with Liberty Tax's claim for breach of contract, which is that the defendant breached the parties' purchase and sale agreement by failing to assign 5 leases to Liberty Tax in 2019. The evidence before the district court at summary judgment regarding the circumstances of those 5 leases was sufficient for a jury to find for Liberty Tax on the 3 key issues on appeal. First, that Liberty Tax requested assignment of those leases in December of 2019. Second, that Liberty Tax did not waive its right to request assignment of the leases. And third, that Liberty Tax retracted any waiver when it demanded assignment in 2019 before the defendant had materially changed his position because he had been subletting those leases.
Why didn't they waive, given that they expressly declined to take over some of the leases in 2016 and then waited nearly 3 years before asking to do so?
So I think as to express waiver, the court can look at the 5 leases in 3 categories because the communications relate to those 5 leases in different ways. The first category are the 2 that were not on Schedule C of the parties' agreement, as those are the Allerton Ave property and the Adam Clayton Boulevard property. And as to those 2 properties, the most that we have in the email communications is Liberty Tax's employees saying she's not aware of any other properties that Liberty Tax wanted to assume, but that she would check with her team. And I don't think that statement is the kind of clear, unequivocal, and precise evidence of a waiver that the law demands. As to the 3 remaining properties which are on Schedule C, I think those fall, again, into 2 different categories. The one that I would admit is the hardest for us is the Westchester Avenue property. That's the one where in July of 2016, Mr. Shahabuddin's counsel asks whether he can proceed to dispose of that lease, and Liberty Tax responds, yes, we are not moving forward with that one. That's at JA 198. Now, I think in the full circumstances of the case, including the fact that another Liberty franchisee took over these 5 leases, a jury could look at all of those circumstances and understand that was not precise evidence of an intent to waive forever. But I think that's the hardest one. The remaining 2 are the Fordham Road and Willis Ave properties. And as to those properties, in November of 2016, the correspondence was simply Liberty not taking. And we know from the record below at the argument before the magistrate judge, counsel for the defendant conceded that—
Under your theory, how long did appellee have a duty to hold on to the leases?
In the circumstances of this case, so long as Mr. Cebulski, the Liberty franchisee, was still in those properties, doing work for Liberty Tax in those properties.
So indefinitely?
Indefinitely, so long as the franchisee was there. I think I would have a much harder argument, I'm not sure I would even be here, if there was no Liberty franchisee in those properties. I think for me to come in and say that if he had disposed of those properties, if he had installed a new business in those properties, I don't think it would be reasonable for Liberty Tax to come in 3 years later and say, we've changed our mind, we want them back. What makes this case so unique, both in terms of whether this was an express waiver, whether this was a reasonable time, and whether Liberty, frankly, reasonably retracted any waiver in 2019, is the fact that during that time period, there was another Liberty franchisee subletting these leases from the defendant until December of 2019. That's a critical circumstance in this case because there was no material change in position from the defendant. He had not disposed of the leases. He was subletting them to a Liberty franchisee. The purpose of this provision was to allow Liberty to maintain its goodwill in those properties. It was doing that by having a franchisee there subletting from the defendant. And it was only once that franchise relationship with Mr. Cebulski terminated at the end of 2019 that Liberty needed to go in and request the assignment at that time. Now, on the issue of the request for the assignment, there is, I think, ample evidence in the record that Liberty did make that request in December 2019, notwithstanding the magistrate's conclusion below. I would point the court to 3 locations in the JA where that is clear. First, Mr. Brashear's deposition testimony, which is at JA 232 and JA 360, where he says in his deposition that Liberty Tax requested assignment in December 2019, and that in a December 2019 conversation, counsel for the defendant said the defendant refused to assign the leases. The second is Mr. Brashear's declaration from April 2020. This is a declaration that had been filed earlier in this case at the TRO stage at JA 113. The magistrate judge expressly referenced that declaration in his report and recommendation and at argument on the motion. Liberty Tax then refiled it with its objections at JA 888. But there, again, very clearly, Mr. Brashear said that in December 2019, he spoke with the lawyer for the defendant.
Can I go back to Judge Thacker's question about how long the leases were to remain available for transfer? The language of the PSA talks about a closing date, and it suggests that once these documents are executed, that the transfer of assets, I mean, it implies that it should occur pretty close to the time of the closing date. And the magistrate judge and the district court relied on that language to suggest that there just wasn't reasonable to believe that these leases would remain open for the time period that you suggest. So what about that?
So the magistrate judge concluded that the PSA meant that all of the assets needed to be assigned by the time of the closing. For the reasons that we put forth in our brief, I don't think that's the best reading of the PSA. I think the PSA does contemplate that there will be some discussion or work around the leases even after closing. For instance,
3 years worth of this discussion?
well, I think that's a separate question. So I think whether you think we're right about when the closing occurred or whether you think the magistrate judge is right about when the closing occurred, I don't think answers the ultimate question. And Your Honor's question is the ultimate question, was 3 years a reasonable time in the circumstances of this case? And I think, again, as to these 5 leases, it was a reasonable time because of the fact that there was a Liberty franchisee in those locations. The cases look at a variety of factors and say that it's usually the jury's job to weigh those various factors. Those factors are the purpose of the contractual provision. And here the purpose of the contractual provision is obviously to allow Liberty to maintain its goodwill in its franchise locations that in many cases it had held for more than a decade. And it did achieve that purpose in the short term by having another franchisee sublet those locations from the defendant. But once that franchisee left those locations, it became necessary at that time for Liberty to promptly, as it did, request assignment from the defendant. So that's one factor that courts stick to. When we're talking about retraction of any waiver, let's say there was an express waiver in 2016, and the question is, can Liberty retract that waiver? Courts look at whether there's been a material change in position by the counterparty such that the party who had waived would be stopped from retracting that waiver. And here there's just no evidence of a material change in position, or at a minimum, a jury could find there was no material change in position, precisely for the same reason that there was a Liberty franchisee subletting from the defendant. He had not, as of December 2019, installed his competing tax businesses in those locations. He had not disposed of the leases. He still had the leases, and we know that because in January of 2020, he signed 5 agreements temporarily allowing Liberty to stay in those locations until April of 2020. and it was in April of 2020 when he then gave those leases to someone else to run a competing business. So I think all of those factors are factors that a jury could look at to conclude that in the circumstances of this case, on these facts, on this fact-intensive record, that it was reasonable for Liberty to ask after 3 years. Now, if I may just briefly turn to the counterclaim, there I would make 2 points. The first is that the question on the counterclaim is whether the definition of net revenue in the parties' PSA, which was carried forward to the settlement agreement, includes the e-filing fees, and there's really 2 points there. The first is that e-filing fees, a jury could conclude, are not net revenue received for the offices and the territories because, as explained in a declaration of Liberty's employee, they are not fees that are generated at the office locations. They are a separate kind of fee that is generated by Liberty, the franchisor, and then only a portion of that fee is remitted to the franchisees.
Why were they included in the spreadsheet as gross fees then?
The spreadsheet included gross fees that were related to all of those locations, but they were the reason Liberty subtracted them out of the spreadsheet.
Because it didn't want to pay them.
Well, it didn't want to pay them because they weren't the same kind of fees that it believed qualified as net revenues. It subtracted them out precisely because these were Liberty fees, not franchise fees. Unlike, by the way, everything else that is identified in the definition of net revenue in the PSA. The franchisees are the ones that receive fees from customers. The franchisees are the ones that then expense money back to customers through things called cash in a flash and send a friend, all of the things that are identified in that definition. And so I think if you look at that definition as a whole, you can understand that these are the fees were contemplated to be fees that were fees generated at the locations, not fees that Liberty, the franchisor itself, collected. At a minimum, we think there's a dispute as to what the right amount is, because as explained in the Declaration of Liberty's employee, a portion of that $432,000 would have been remitted back to the franchisee, but not the entire amount.
Well, as to the electronic filing fees in the agreement, and what somebody testified that electronic filing fees are not expenses like discounts, cash in a flash, send a friend, or uncollected fees. So if it wasn't excluded as those cash in a flash, et cetera, why isn't it part of the net revenue?
Well, our position is it's not part of net revenue because net revenue starts with the gross fees that are received for the office locations before you start subtracting those other expenses. And these don't qualify as gross fees received for the office locations because they are they are fees received for Liberty, the franchisor, not for the office locations. Now, the second issue that I would just briefly address with respect to the counterclaim is the issue of accord and satisfaction. We do think a jury could reasonably read the parties' email correspondence that addressed this issue and conclude that Liberty made clear its intent to proffer this amount in full settlement of the outstanding debt under the settlement agreement.
Even assuming, let's assume that electronic filing fees are recoverable by the other party, it seems to me those fees are liquidated, and so therefore accord and satisfaction would not apply.
I think to the opposite, Your Honor, because there was a legitimate dispute between the parties as to how to calculate those fees. The parties' settlement agreement did not specify a liquidated amount. It gave it referred the parties to the definition of net revenues in the PSA. But it,
Isn't the 10% share thereof, is it readily attainable from Liberty's own records?
well, only if it's clear from Liberty's own records what qualifies as net revenues. And there's a dispute, in our view, a bona fide
I
dispute.
said assuming that electronic filing fees are part of the net revenue. Make that assumption, not.
Sure, I may have missed that part of the
Yeah.
question.
So, just for assuming
Sure.
that, then there is testimony in the record that 10% share is readily attainable from Liberty's own records, and making your defense kind of inapplicable, doesn't it?
I think if you assume, you have to assume two things. You have to assume that the e-filing fees are part of net revenue, and you have to assume that there could be no even bona fide dispute about whether that is true.
Well,
As
you-
long as there's a bona fide dispute about whether it's true, then I think the debt was still
Well,
unliquidated.
in calculating those fees, the only thing that's considered is, as I understand the record, are your records. So where's the dispute if it's your records?
The dispute is what is the term gross fees received for the offices and the territories mean in the first place?
Well,
And
I mean,
our
I'll-
record contains
I'll
both.
give you that, but assume you're wrong. Then getting to the second point, is there any other evidence other than your own records that determine the amount of the electronic filing fees?
Well, our record is the spreadsheet in which Liberty deducted those fees from the amount due to the defendant based on Liberty's interpretation of the PSA and the settlement agreement, that those do not count.
Well-
But there's no dispute about what the amount of the e-filing fees are. That's in the spreadsheet.
That's the point I'm trying to get to. If you're wrong about the electronic filing fees, then the amount is liquidated as per your own records, and accord and satisfaction would not apply.
Yes, so long as there's not a bona fide disagreement about whether they qualify.
There's an
I see
even
I'm
more,
over my
well,
time.
hold on a second. There's an even more fundamental problem is that you didn't raise this defense until the R&R stage, and so the district court, in its discretion, decided not to consider it, so why should we?
It's unclear whether the district court declined what the district court decided. The district court didn't address it. It did address other
But
arguments.
we know it wasn't raised until the R&R stage, right?
That's correct, Your Honor. I think that this issue clearly falls within an argument that is goes to a preserved issue that this court held in both George and Samples. A district judge does need to consider at the R&R stage, and I think the best evidence of that is if the court looks at George. One of the issues in George was a criminal case, so it's a little bit different, but one of the arguments that the government raised at the R&R stage in George was whether suppression was not required because of the inevitable discovery exception to the exclusionary rule. That's an exception on which the government bore the burden of proof, much like an affirmative defense. And this court held that the district judge needed to consider that argument at the R&R stage. We think this defense is very similar to that. And I would note the defendant did not object below to this issue being before the district court. He simply responded on the merits to the issue at the R&R stage.
All right, thank
Thank
you.
you.
Mr. Harvey?
Your Honors, may it please the court. My name is James Harvey from Woods Rogers Van Deventer Black on behalf of Mr. Shahabuddin. Your Honors, typically civil cases, contract cases present some even arguable factual issue. What is remarkable in this case is the utter dearth of facts in the record to support the appellant's assertions in its original complaint and then upon it in defense of its summary judgment motion. The evidence that supported the only conclusion the district court could make included the agreement drafted by Liberty, the clear written exchange between its in-house counsel and counsel for Mr. Shahabuddin in 2016 affecting the purchase and sale agreement, the sworn testimony of Liberty's CEO who approved of, negotiated, and signed the agreement, and the deposition testimony of Liberty's representative, its treasurer, Mr. Brashear. No facts are in dispute that Liberty gave explicit language of a waiver, implicit language based on the agreement and the actions of the parties of a waiver for any right of assignment to the subject properties in 2016, which is the operative time. This case is really just a test for this court to see if it's going to go back on its prior decisions and that of the Supreme Court and permit a party to attempt to create a disputed fact where none exists when it attempts to differ its sworn testimony.
But then why was appellant's assignment right preserved in paragraph 4A of the 2018 settlement agreement? Doesn't that show that the parties understood that appellant's assignment obligation remained in
Your Honor,
force?
I think the district court aptly described that obligation. That obligation arose in the representations and warranties section of the purchase and sale agreement. What is notable is that the separate obligation to assign and transfer these leases were superseded by the settlement agreement. The representations and warranties were effective as of two dates, as plainly stated in the purchase and sale agreement: the date of execution and the date of closing. And they serve a simple purpose: to prevent a fraud or some type of misstatement of fact to be relied upon by the buyer at closing. Namely, that you will take certain actions, you're going to assign me these things by closing, and that they're going to have good title. Those things don't go away in 2018. For instance, if the buyer discovered that one of the leases that it had been assigned was forged or fraudulent or didn't carry good title, then Liberty could turn back at Mr. Shahabuddin and say, you breached this representation and warranty that you made effective at the time of the closing. That does not change. The 2018 agreement, as the court noted, does not create some new or renewed obligation to assign properties into the future. So here, all we have to attempt to create factual disputes is the Liberty attempting to counter its own statements under oath with other statements under oath. And this court in Barwick v. Celotex and Stevenson versus City, as well as Supreme Court in Cleveland, have all said that a party cannot create a genuine issue of material fact to survive summary judgment simply by contradicting his or her own sworn statement. And that's what we have here in multiple contexts.
So is your argument that Brashear's affidavit that he formally demanded assignment of the leases for the locations was too late?
Your Honor, the
That the
timing...
time at which he said he demanded was too late?
I want to understand the contradictions between the sworn statement, or are you saying that...
Let me just ask, what is your rebuttal to Mr. Brashear's affidavit?
He stated under oath during his deposition that he had no recollection of what occurred in any conversation in December of 2019 to demand a assignment of any leases. He has no recollection of referencing the purchase and sale agreement. He has no recollection of what was specifically said.
Was that deposition before his affidavit?
It was after his affidavit. We took that affidavit. We attempted to ask him the specifics of what occurred.
Okay, so he had no specific recollection?
No.
But his affidavit is pretty specific, that he says he formally demanded that appellee assign leases for the subject locations.
Which is an interesting turn of phrase when he says he formally demanded. So, of course, like any attorney, we ask, how did you formally demand? And he says, I have no recollection at that point. And so but I think we're going down a path that the district court said didn't matter at the end of the day. Whether or not there was a demand in 2019, those rights had already been waived back in 2016 by both the express and the implicit actions of the parties.
And I guess that's where my question was going, that the demand was too late, is
That's
your
right.
argument.
That's your right.
My first question.
Okay, and so exactly in 2016, if you look at that, this is a unique situation. We know that waiver requires proof of a knowing and intentional waiver of a known right. And here, there's definitive contemporaneous written exchange demonstrating a clear and express knowing waiver, and the principals on both sides of this transaction in 2016 agree that it was intended to act as a waiver. These issues are not in dispute. And Liberty presented no evidence to the district court to counter what was presented on summary judgment. The language of the PSA, the language that Liberty relies upon is that representations and warranties. And that makes sense because it carries forward about what was known at the time of the transaction. What can we rely upon going forward? It doesn't constitute some continuous obligation. Instead, the parties acted clearly, expressly, over a close period of time between the end of June 2016 and December 4th, 2016, to transfer, to effect the closing, the purchase and sale agreement, resulting in a wire transfer of the rent payments for those properties that were assigned for June and July of 2016. So and it's important to understand that when Liberty says that we are not taking these leases and that you are free to dispose of them, they're not saying wait and hold on and get somebody else's lease. This is not a favor to Mr. Shahabuddin. Instead, it's a burden upon him because he now has leases. He has property with no tenant. He's now stuck with property. He has to go find something to do. And what I'll say is that Liberty's argument here today is an extraneous fact not in the record. They now want to claim that because there was some other side lease, some sublease, that excused them from their performance. But that's not in the record. What's in the record, and they cite to, is JA 946, 948, 949, which is the testimony of Mr. Brashear about subleases that existed to a Liberty franchisee in 2019, in December 2019. The record is devoid of any facts of actual subleases that existed in 2016. In fact, the district court, the magistrate judge, rejected discovery on that topic before summary judgment was granted. That was not relevant to this dispute, and we can see why. This is an agreement between two parties, and whether or not one of those parties has another side agreement, that may motivate them to take certain actions, but it doesn't change their responsibilities as between Liberty and Shahabuddin. They may have their own reasons for what they did, but that does not change the obligations between the parties, and there's no evidence in this record of these subleases. Instead, what is in the record is that Mr. Shahabuddin had control of many franchises at the purchase and sale agreement, some 37. He assigned exactly the ones that were requested. The others were not. There was clear language in June and July that he was not going to take the 2168 property. There was a request for properties not on Exhibit C, those intended to be transferred, and counsel followed up. What other ones do you want? And counsel for Liberty, its own employees, said, we are not aware of any. I'll let you know. But it's not like this was on a list where anybody could follow up and say, what about this one? What about that one? These were ones never intended to be assigned, these last two. There was a clear statement, not aware of any. I'll let you know if we want them. Never happens. In December of...
Until 3 years later.
Exactly, until 3 years later. But closing, the last of the assignments, and the PSA defines when closing occurs, which is the submission of these assignment forms. The last one occurs in December 2016. That's when the transfer, the wire transfer happens, consideration that affects that closing. So during the period of closing, the parties had a clear expectation of what was to occur, and their CEO expressly stated under oath that once that occurred, they had no expectation that these leases be held open in the future. The CEO of Liberty stated it did not expect Mr. Shahabuddin to keep them available for assignment indefinitely into the future. This is not contradicted. There's no factual evidence otherwise. That's express language. It's implied language by the meaning of the purchase and settlement agreement, which provides specific actions to be taken upon closing. There's no other obligation. Liberty would have this court read new terms into that purchase and sale agreement. Purchase and sale, assign to us everything now, and by the way, keep holding on to things in case you have a subtenant franchisee of ours. That's the argument Liberty now makes, is they want to insert additional language into this purchase and sale agreement that exists nowhere. And the statement that there was no change in position is also not indicative of what's in the record. Mr. Shahabuddin, at the time of transfer in 2019, was only the lessee of one of these 5 properties. In the interim, other wholly owned or other special purpose entities had taken new or renewed leases on 4 of the 5 properties because of his intent to have other commercial ventures there. So he is not even the lessee of 4 of these 5 properties in 2019. There was ample evidence to say that, of course, he has a changed position, but it doesn't matter. Retraction is not available, of a waiver is not available in Virginia. So as the district court found in 2016, relying on Franklin Plant Farm v. Nash, when there is a non-continuous obligation, you can't later retract a waiver of that obligation. The right to consent, in that case, the right to consent or object to a lease assignment was not a continuous covenant, but a single act which, once waived, could not be retracted. The district court properly found these obligations in the purchase and sale agreement to assign these properties was just like in Franklin Plant Farm, a single act that once waived cannot be retracted. There's no other law in Virginia that would permit an ongoing obligation. And so it does not matter what happens in 2019, because once they waive it in 2016, once the CEO says, I have no further use for this, I don't expect you to hold it open, you can't go back and undo that. With regard to the counterclaim, this is another example of trying to change the testimony to create a material fact. The material fact they now want to create is that the settlement agreement and the definition of net revenue that is referenced in the purchase and sale agreement means something other than the plain language on its face. It means something different than what Mr. Brashear testified to as the company's representative, as its treasurer. He testified that he knew exactly why Liberty did not pay electronic filing fees to Mr. Shahabuddin. And that reason is not a reason that Liberty comes to this court today. The reason he stated under oath was because electronic filing fees didn't exist in 2016. Of course, that's a nonsensical argument. As the court has already recognized, net revenue is just gross revenue less these express discounts that are in the agreement. So whether or not there's some other form of income, it doesn't matter. They now want to say that, well, it's not for the franchises. But again, this contradicts Mr. Brashear's testimony. He was asked expressly, is this revenue for Liberty and its franchisees? And he said yes. So they can't come now before the court and say that it's not revenue for the franchisees, so therefore it's not included. Doesn't make sense. With regard to the accord and satisfaction, as the court has noted, well, we can just look to the federal rules and find that accord and satisfaction is an affirmative defense. It wasn't raised. It was their obligation to do so. But as the court has also recognized, they don't meet the elements for accord and satisfaction in this case. We can at least take 2 of the 3 requirements in Virginia. So in Virginia, there are 3 requirements: that the amount be liquidated, that the amount be disputed, and that there must be sent a clear statement that the payment was made in full satisfaction. We don't have the first or the third. What they have now is they now want to dispute that the amount should be paid under the purchase and sale agreement despite their own spreadsheet. As the court noted, this is different than, that conflates the dispute issue with a liquidated amount. And in here, the district court found that the exact sum was readily calculable by looking at the Liberty's own documents. So there's no dispute that it was a liquidated amount. Accord and satisfaction cannot apply. In addition, the court can look to the conversations between the parties and see that there was no clear statement or actions that this was made in full satisfaction, so that it was free at that point to render summary judgment on this issue, whether or not it had dealt with the accord and satisfaction issue. The elements just weren't there. The court properly acted to grant summary judgment, and we ask the court to affirm the judgment of the district court.
Thank you, Mr. Harvey. Ms. Sahara, you have some rebuttal?
I'll be brief, Your Honor, because I know I went over in the opening argument. It is absolutely in the record that Mr. Cebulski was the franchisee was subletting these leases from the defendant. Mr. Brashear's earlier declaration, this is at JA 114, says that after the parties entered into the PSA, Liberty franchisee Mike Cebulski operated Liberty franchises from the subject locations. The magistrate judge asked counsel for the defendant about that at the hearing on the motions, and counsel for the defendant represented at JA 803 that Mr. Cebulski began subletting those properties in November of 2016. That is the exact same time when Liberty and the defendant were emailing about what was going to happen with those final properties. And so when Liberty said it was not taking those properties, a jury could conclude from all of the circumstances, including the fact that Mr. Cebulski began subletting in November of 2016, that was nothing more than a recognition that Cebulski was taking them, not that Liberty was forever waiving its right to assignment.
Did Liberty say that was the reason?
That does not
In the
reflect,
emails?
it is not reflected in the emails. The emails that just say Liberty not taking, but the standard for an express waiver is a demanding one. It requires clear, precise, and unequivocal evidence. And it allows the jury
Liberty not taking is pretty clear.
I think the jury is entitled to look at all of the evidence, including the extrinsic evidence, to determine whether that was a clear and express waiver. And I think, again, because we know that at the same time there is a Liberty franchisee that is going into those locations, a jury could conclude that was not an express waiver. Counsel relied very heavily on the affidavit of Liberty's fired CEO, John Hewitt. And on that, I would just note that his affidavit says that Liberty did not expect Mr. Shahabuddin to keep these leases in perpetuity or indefinitely, and that's not the argument that we've presented to the court, so there's no contradiction between that declaration, even if it had any credible evidentiary weight on this issue. And then just briefly, with respect to the settlement agreement, counsel now suggests that some other provision of the PSA is the one that required transfer of the leases. That is not what they argued below. They repeatedly pointed to Section 8E as the operative provision requiring transfer of the leases. To the extent that all the parties intended to do at the settlement agreement was preserve other parts of 8E, including the representation about good title, the parties could have carved out that particular sentence as they did elsewhere in Section 4A of the settlement agreement. So for all those reasons, as well as the ones I previously articulated, we ask the court to reverse.
All right, thank you both for your arguments this morning. We, as you heard earlier, would typically come down and greet counsel. Not able to do that today, but hope to be able to do that in the near future. Thanks very much.
Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated. Final case is the Prudential Insurance Company of America versus Shenzhen Stone Network. Mr. Barlow.
Good morning, Your Honors, and may it please the Court. Benjamin Barlow for the appellant, Shenzhen Stone. Your Honors, as a brief introduction, my client appeals the decisions below on 3 grounds, and we're talking about 2 separate decisions. There was an early decision on a motion to dismiss based on the concept of in rem jurisdiction, and then there was the decision immediately below on summary judgment that's being appealed. The 3 reasons my client appeals. First, the district court erred in exercising in rem jurisdiction when personal jurisdiction was available over the domain name registrant, if not at the time of filing, as soon as a responsive filing was made in the case. A subset of that, waiver is not an issue in this case. In rem is jurisdiction over a piece of property. It was raised at the trial court level. It was raised in the consolidated briefs on appeal, and it deals with jurisdiction over the property itself. So dismissal of an individual, the registrant, Mr. Zhang, doesn't affect that question of whether in rem jurisdiction is properly exercised over the piece of property. 2, the district court erred in finding that registration under the Anti-Cyber-Squatting Consumer Protection Act encompasses re-registration. Registration in the context of the ACPA is clearly dealing with the creation event that results in the creation of a domain name, the event that puts all on notice that there's an existing domain name out there. So if you're trying to get your trademark, you know that someone has a domain name that you're not going to be able to get.
Well, we haven't spoken on this issue, but other courts have. Is there any disagreement with the other courts on that issue?
Yes, Judge Floyd, there indeed is. I believe that when we address the issue this morning, that this court hopefully will reach the logical conclusion that the Ninth Circuit applied in the Go Pets decision, where registration is that original registration and not a re-registration with a new registrant. There have been other cases. The Visor case in the District of Columbia goes along with Go Pets, but then there's the Xerxes case in the District of Columbia that tends to take sort of the Third Circuit positioning that's in the Schmidt-Heide case. I believe that case is distinguishable because it dealt with a specific question about registration of an individual's name as a domain name, and whether, when the law changed and made that improper, whether a re-registration would relate back. But even the decision below is a little bit inconsistent when it comes to that issue of registration, because the court interprets the Go Pets decision in the Ninth Circuit as being inapplicable, because it says really the issue before the court in the Ninth Circuit that they thought was important was the fact that the transfer of a domain name there was to an associated entity. A brother transferred a domain name to an entity that was co-owned by his brother and himself. But that wasn't the issue. The court below thought that we were talking about the importance of the Go Pets decision was because you had a transfer to a related entity. But that was not the Go Pets holding. The Go Pets holding is crystal clear that a re-registration to a new registrant isn't registration for purposes of the ACPA.
Wouldn't we be rewriting the statute? I mean, the statute talks about registration. It doesn't say initial registration. So why would we limit it to the initial registration?
I think that's an important question, Judge Diaz. And I think the issue is that to interpret the statute the way Prudential is arguing that the statute should be interpreting, it's not adding words. It's doing the ultimate elevation of form over substance. It's saying because you have the word registration and then you talk about a re-registration, no matter what's really happening when something is re-registered, just because you have the word registration encompassed in re-registration, that those have to be the exact same situation that we're talking about, but the context makes clear that it's not. The context makes clear that what we're talking about, and this is what the Ninth Circuit focused on in Go Pets, what we're talking about is the creation of property rights in a domain name. In the Booking.com decision that the Supreme Court had, they acknowledged that a domain name confers valuable property rights. Well, what the Ninth Circuit said is that if you create a domain name and you have valuable property rights in that domain name, if we say that a re-registration is the same thing that happened when you registered and created the name in the first place, what we're telling people who register domain names is that their property rights in their domain name are always subject to someone else's decision to trademark a name.
The statute, go ahead, I'm sorry.
Isn't the purpose of the ACPA to eliminate cyber squatting? So why logically wouldn't we consider re-registration as being available?
Judge Floyd, I think it's clear even, I think it's JA 223, if I'm right, that's the court's decision below, where even the court says at the end of it, it says clearly re-registration to a related entity is not the same as registration. The court makes the distinction and says, well, re-registration's not really registration, that really what we're focused on is the transfer or assignment of interests. And when you get to that point, you go straight into the Ninth Circuit's ballywick by saying that if you tell someone that they can create property rights in a domain name in good faith because there's no existing trademark out there, then if somebody later, somebody like Prudential who was on notice that they did not have the pru.com domain name, they knew that going in when they got their trademark, if you let that trademark owner then just sort of lie in wait for a person to want to sell their domain name or transfer their domain name, I don't understand the court's distinction below because I don't know why that would be. I don't know why the transfer would make a lot of difference if you're transferring to your mother or your brother or your sister or a related business. It's the transfer that the court's talking about. And the Ninth Circuit said that if you adopt that understanding of re-registration, what you're doing is you're making those property rights in the domain name inalienable. People can't sell the rights. The Ninth Circuit in the Heiss situation, it was a gentleman named Heiss that owned the GoBets domain name. They said that there's no question that if Mr. Heiss had just retained ownership of his domain name, that he could have used it however he wanted to. So why wouldn't he be able to sell the totality of rights that he has in that piece of property to someone else? The alternative approach would be to say that someone's later registration of a trademark should affect your ability to sell. It should affect the type of people you can sell to. Maybe you can only sell to a person that you're related to or a business that you have ownership in, but it restricts your right to sell.
Mr. Barlow, I'm sorry to interrupt you, but I'm not sure that you answered Judge Floyd's question. The purpose of the statute is to prevent bad faith registrations, cyber squatting of domain names for a non-legitimate purpose. And if that's the purpose, why does it matter whether someone does that on the initial registration or on re-registration?
Judge Diaz, I think I would take a step back and absolutely, the ACPA, the intent as it is to prevent cyber squatting. The reason I think what you should look at, the registration you should look at under the ACPA is the original one. And there's no question here that the original re-registration, there was no pru.com or pru trademark. So there's no question that that was registered or there's been no argument that that was done in good faith. I think that the question I think the court should look at is the concept of notice that flows throughout the Trademark Act. What we're concerned about is just as a domain name registrant, when they register, when they create a domain name, and they are on notice that there's an existing trademark, they know that they're running a...
So your answer is that it's not bad faith that we need to consider, it's whether there was notice or not?
I think we look, I'm
Still
sorry.
trying to get the answer.
Well, I think you do look at bad faith, but you look at bad faith at the time of the original registration.
Why is that?
Because when that original registration happened, when the domain name was created, there was no trademark. Those rights in the domain name were created and sprung up, and they didn't have anything to do with the trademark. And the person who owns that initial domain name, who does the initial registration, just as they have the ability to keep it and use it despite the fact that Prudential's registered the Pru trademark, they should have the ability to sell the full panoply of rights that they have in that domain name to anybody else, to transfer it. We shouldn't always be looking in to say, what did you
So
re-register?
if there's bad faith in the re-registration, it doesn't matter?
I don't think the bad faith analysis is conducted. It should be conducted the same way. I think you should look at bad faith in the creation of the domain. But a re-registration of the domain, a periodic transfer that can happen simply by clicking a button on an email, I don't believe that's what the ACPA is focused on. I think the ACPA is focused on, did someone create a domain name knowing that that domain name was taking from somebody who had a trademark? That's the whole purpose behind the Anti-Cyber Squatting Act. It's, does somebody create a domain name knowing that while knowing that somebody already has that trademark, and are they doing it so that they can hold that ransom for that person, so that company has to do it? That's the whole scheme of the Anti-Cyber Squatting Act, to make the clock start clicking again every time there's a transfer, and then to put it on courts, to put it to the court's responsibility to determine whether the transfer happened, I guess, to an acceptable related party or to an unacceptable related party. That seems more difficult than focusing on the creation event, because I think what's important in the trademark event, in the Trademark Act, is when you create a domain name, are you on notice that someone already has a trademark? A trademark owner, when they register their trademark, they're putting everyone on notice that we're claiming rights in this mark. If they know that there's some pre-existing use of that mark somewhere else, well, it's the notice that's important in what they have. And I would suggest that that's the rubric that you should use here in determining whether a registration and a re-registration are synonymous, because the court below seems to think that re-registration is not synonymous with registration as long as you're talking about a re-registration by somebody who's related or a related entity. That's not workable for the courts. When you're looking at the assignment of ownership, we don't suggest that for trademarks and copyrights, that when someone assigns their ownership interests in a trademark or copyright, that somehow that starts the clock ticking again. So, for example, if an entity gets a trademark and I register or I have infringing use, I have, I don't know, I've printed out banners, I've printed out everything. I'm intending to use their trademark when I'm first available, when I can first use it. Do I just need to wait until they transfer or assign ownership of that trademark to someone else and try to, in that brief window of time, start my infringing use? And does that get me off the hook because somehow they've assigned their ownership? Is what they assign to someone else, is that less than what they created for themselves when they first secured rights in a mark or a copyright? I don't think that's the answer to this question. I think the Ninth Circuit's position on this is logical and makes sense, and I don't love the position of coming into the Fourth Circuit and saying, hey, let's do what the Ninth Circuit did. But in this situation, I think they got it right. that the domain name is property rights that are created. And if you let this happen and you consider a re-registration to be the same as the registration, well, then all of a sudden you've limited a person's ability to sell or transfer or assign their property rights. They're either limited in who they can assign those rights to, who they can transfer those interests to, or they're limited because they can only accept offers for the domain name from people who are willing to then go through a cyber squatting case against them. I would like to turn to the issue of in rem jurisdiction as well, but my time's out and I can address any questions related to that in rebuttal.
All right, thank you, Mr. Barlow. Mr. Partridge.
May it please the court. I'm Mark Partridge with Culhane Meadows, appearing on behalf of the plaintiff, Prudential Insurance Company of America. Before getting into the remarks I wanted to bring to the court's attention, I'd like to answer the question that was on the floor. Essentially, the idea I think the court was asking about is if you register a domain name, does that mean that forever it can never be challenged for bad faith use? And the answer is clearly no, and the argument presented is clearly wrong. Judge Sotomayor, sitting for the Second Circuit years ago in 2002, in the Story versus Cello Holdings case, made the point that a domain name is a contingent right, if anything, contingent upon the fact that it's not being used for a bad faith use. As with trademarks, if the use of a domain name changes from a legal use to an infringing use, the Lanham Act applies. The same thing here. If a domain name is changed to an infringing use, it is subject to challenge under the ACPA under the bad faith clause. And the argument presented in Go Pets and the argument presented here today would mean that that was not true. It would create a loophole in the ACPA that essentially would destroy the ACPA from using that statute against a wide range of domain name infringements.
Mr. Barlow, I guess can correct me if I'm wrong, but I thought I understood his argument to be that if Prudential were interested in protecting its interests in the domain name, it should have litigated that issue when the name was first registered.
There's nothing in the record to show that that was a time when it was being put to an infringing use. And so it had no obligation to do that. What happened here is in 2017, it was registered by the claimant and put to an infringing use. And at that point, Prudential has the right to bring a case under the ACPA. It is not barred under the ACPA by the fact that there was an initial registration and then a re-registration. And that's the point of the majority of the cases that deal with the meaning of registration under the ACPA. But I'd like to deal with that in a little bit more detail and get into why Judge Ellis was correct in his decision and what it means for this court. So I'd like to address, first of all, the whole circumstances of his ruling for registration. Then, time permitting, turn to the district court's ruling on bad faith here, the summary judgment decision itself, and the safe harbor argument. If necessary, we'll proceed with the in rem argument as well. But our point here is that the motion to dismiss was an appeal filed by Mr. Zhang. The summary judgment decision was an appeal filed by Shenzhen Stone. There were two separate appeals. This court, the Fourth Circuit, dismissed the appeal filed by Mr. Zhang, which covered in rem jurisdiction. And so that is not properly before the court. The only issues raised by Shenzhen Stone in its appellate statement filing was the summary judgment issues. And in rem jurisdiction was not at issue on summary judgment.
Well, as to their SSN's opening brief, they didn't waive, they didn't raise the in-rem jurisdiction issue, did they?
SSN did not join in that argument about in rem.
So is it
Zhang
waived?
argued in rem, and then his appeal was dismissed.
So is it waived?
Yes, we would say it's waived. It's not properly before the court. They did not raise it themselves. Shenzhen Stone did not raise it themselves until they got to their reply brief. So it would be waived. But also before it was waived, that appeal was dismissed and is not properly before the court. I could turn to more about that later, but I think I'll get to registration, if I may. So the issue, just to be clear on where this arises under the statute, the issue that we're talking about for registration is the provision that states that a person may be liable in an action by the owner of a trademark in the case of a trademark is distinctive at the time of registration of the domain name. Here, Judge Ellis correctly found that Prudential's Pru trademark was distinctive at the time claimant registered the Pru.com trademark in 2017. Claimant contends that the relevant registration is the initial registration by an unrelated third party in 1997, not claimant's registration in 2010, as discussed. However, the authority they rely on, Go Pets particularly, the case from the Ninth Circuit, is a discredited minority view, and it's inapposite to this case, as Judge Ellis explained. The court should reject claimant's position on the meaning of registration under the statute as going too far and recognize Judge Ellis's reasoning as the appropriate approach for a number of reasons. First of all, Go Pets does not apply here. In that case, the initial registrant re-registered a domain name in the name of a company he owned. That's what Judge Ellis found. It's not a case involving a registration by an unrelated third party who registers the domain name after purchase. That's what we have in the Prudential case. As Judge Ellis notes, those facts are inopposite. So you can take a narrow view of Go Pets that it applies to the specific circumstance of the case, and those circumstances are not presented here, so Go Pets does not apply. That's what Judge Ellis said.
Well, I mean, but the holding of that case didn't make that distinction, I don't think.
It didn't make that distinction, but those were the facts. And when we interpret a case, the narrow view of a case would be to limit it to its facts, rather than take dicta from the case and argue that based on the decision for these facts, we're entering a ruling that will apply to all possible interpretations of this. It suggests that Go Pets goes too far, but it is not controlling over this court, and it's not the majority view. The second point, I think, has already been touched on here. If you look at the plain language of the statute, it doesn't say anything like initial registration, original registration, or anything like that. In fact, the argument of Mr. Barlow was that the registration that matters is the original registration. Well, the words don't say that. And the majority of courts who have addressed this issue are stating that registration includes a registration at a later point in time. That lets you enter the court making an ACPA claim. It doesn't mean you violated the ACPA, but you get to come into court and make your argument that something happened that was in bad faith. And that view is the majority view and is appropriate. And it's consistent with the plain language of the statute. It's consistent with congressional intent. As Judge Floyd pointed out, the purpose, and is admitted, the purpose is to protect trademarks from cyber squatting. the statute should be interpreted in that light. The proposed limitation would take a large group of cyber squatting issues and say those simply cannot be brought into court. It would narrow what the ACPA applies to, and that's not the congressional intent. Next, the public policy related to that. What would this mean if you said that the only thing that matters is the first registration? That would mean cyber squatters could engage in a series of re-registrations, finally for the purpose of using it for an unlawful purpose, and the ACPA couldn't be used. And that's contrary to the Story case, the point that Judge Sotomayor was making, that the right under the registration, a contractual right, is contingent upon it being continued to use in good faith. And when those circumstances change, as they did here, that you're not barred by the statute from bringing it. The re-registration is a registration that can be brought in before the court. And then there's the authority. Judge Ellis recognized the leading authority here. The Fourth Circuit has not decided on this issue. But Judge Ellis followed a leading case on this, the Jeske case from the 11th Circuit. Jeske comes after Go Pets, explains why Go Pets is not the appropriate approach. It treats a domain name as an absolute property right in gross, which is contrary to the purpose of the statute, and instead relies on the plain language of the statute. Registration would include a re-registration, which is a registration. It's not a different thing. There are different registrations along the process. And the way the domain name was registered here, and it's repeatedly acknowledged in the briefing of claimant, is that Shenzhen Stone registered the domain name in 2017. Shenzhen Stone is the owner of that registration. That registration is made by going to GoDaddy and entering into a contract with GoDaddy, which they did in 2017. That's a registration that can be challenged here. The only appellate court that has seen it otherwise predates the Jeske case. That's GoDaddy, as already mentioned. So the most recent case is a case from Utah, in structure, cited in our materials. That, again, it's the most recent decision on this topic. And again, it goes through the analysis and explains why the Go Pets rationale is not correct. That's the infrastructure decision in 2022, so it's quite recent. One of the concerns that was raised is that, well, if you take and say that the registration is a property right and that this prevents alienation of the right. Well, Judge Ellis recognized that that issue can be solved by analyzing the case under the bad faith factors, not by excluding all of those cases from the ACPA, but by analyzing them and saying, okay, this domain name is not being used in bad faith now. So the ACPA would apply to the new registration, and you'd make an analysis, and under appropriate circumstances, the new owner would prevail. But if they are a cyber squatter, they would not be shielded by this limited reading of registration proposed by Go Pets. So that would be that's the prevailing weight of authority. Those are the reasons why that authority is right. And we'd urge the court to follow that approach and affirm Judge Ellis's ruling on this issue about registration. I want to turn to the facts, though, that are before the court. We contend that the status of the Prue mark in 1997 is not relevant because the relevant registration is 2017. Claimant says, well, we had no rights to Prue in 1997, and there's nothing in the record that says so. That issue wasn't debated, but there is evidence in the record to show that Prudential had rights before 1997 and that the mark was distinctive. And that evidence is the registration of Prue that came after 1997. It was registered after 1997, but it asserts a first use date of 1968. That registration constitutes prima facie evidence as a matter of law that those facts are true.
Was there a registration in China, and does that matter?
It doesn't matter here, Your Honor. China is,
but was
registration is not at issue. What matters is what happened in the United States.
But there wasn't one in China,
There
correct?
was not a registration in China.
You're saying it doesn't
In
matter?
1997, no. This is the issue of was the mark distinctive in the United States to take action under the Lanham Act. So the record has that fact in it. Plus, that shows up with the affidavit of Allison Lazaro. She also gave evidence that Prue has been widely used for as long as anyone can remember as a nickname for Prudential, for the company Prudential. And Prudential has used that trademark for over a century. So Prue is tied to Prudential, and these are undisputed facts, would be sufficient to establish distinctiveness for the purpose of the ACPA. So you have the ability to make a decision based on the record before you. Based on this record, the court could find de novo that Prudential's rights in Prue were distinctive at the time in question, even if you have to rely on the first registration, which we believe you do not. The 2017 registration is the correct one to view based on the prevailing authority and Judge Ellis's decision. In short, we feel you should follow the trending weight of authority to decide that that is the right registration. Follow the weight of authority expressed in Jeske and reject GoPets. In the alternative, you can take a narrower approach, the middle path suggested by Judge Ellis, where GoPets is limited to the narrow facts of the case, a chain of title that doesn't involve the sale to an unrelated third party and then a new registration. Take that narrower view, the path suggested by Judge Ellis. Either way, this court should affirm the ruling that Prudential is entitled to pursue its claim under the ACPA. So that's the
Even under that narrow rule, though, I mean, if a party were to transfer the domain name to a related party and all that happened in bad faith, that's not a workable rule, I don't think.
The narrow rule that GoPets only applies. Well, we urge you not to follow the GoPets line of authority. We would say that Jeske and the weight of authority is that the statute means registration, which includes a re-registration, a new registration. That brings you into the court, and then you have to analyze whether there's been bad faith to find if there's any liability or not. You're not barred from going into the court because the domain name was registered 20 years ago and now it's being put to a different use.
Talk a minute about the safe harbor argument.
Sure, Your Honor. So, Judge, to be short, they attack it. Judge Ellis said, and he's considering the safe harbor, he says, for the reasons set forth supra, ACPA safe harbor does not rescue Shenzhen Stone here. Accordingly, the ACPA's safe harbor does not apply, and the pru.com domain name must be transferred to Prudential. So Judge Ellis considered the defense. It's not something that he just said, no, I'm not going to take a look at that. He considered it, but he concludes that it's not available here. And in doing this, he's consistent with the prevailing law in this circuit. He followed the prevailing law in this circuit, the virtual works case with Volkswagen, which says a defendant who acts even partially in bad faith in registering a domain name is not, as a matter of law, entitled to benefit from the safe harbor's provisions. One of the factors in the safe harbor defense is whether the person believed that this was lawful. The second, that's subjective. The second is whether they had reasonable grounds. You have to have both. They have to have a subjective belief and reasonable grounds to believe the domain name was in fair use or otherwise lawful. Judge Ellis considered these and found that the claimant had failed to present material facts sufficient to create a genuine dispute about a reasonable belief that this was lawful. They did not have a reasonable belief that this was lawful in Judge Ellis's case. And now what is he doing to decide that? The only evidence presented comes from the self-serving testimony of the company's CEO that is not supported by corroborative evidence. As such, it's insufficient to create a genuine issue. And what's striking is the complete absence of the kind of corroboration you'd expect a company to have. No business plans, marketing plans, no budgets, no documents showing an allocation of resources or people to this project, and no contemporaneous correspondence about what the plan was to do with this. There's nothing like that. The only documents that show up are a handful of things that the judge noted were suspicious. They are not authenticated except by an attorney who lacks personal knowledge, and they appear to all have arisen after this dispute arose. So they're suspicious. At any rate, he found they were insufficient to create a genuine dispute on this issue of whether they believed that what they were doing and had a reasonable grounds for believing what they were doing was lawful. So the safe harbor defense doesn't apply as a matter of law, and it's not appropriate here as a matter of fact.
All right, thank you, Mr. Partridge. Mr. Barlow, you have some rebuttal?
Yes, Your Honor. My colleague refers to self-serving affidavits of Mr. Zhang below, but it was my colleague who brought up Ms. Lazaro's her affidavit as being very instrumental in this case. Before we jump on, since there was the issue of facts raised, this court in Jacobs said that a trial court at the summary judgment stage cannot make factual determinations, cannot make determinations of credibility. If you go to anywhere from JA 1173 and JA 1175 through 1182, you'll see all sorts of determinations of credibility that were made by the court below. You will see that the court, even when describing Mr. Zhang's reasoning for wanting the pru.com domain, the court refers to it, borrows the Second Circuit's language that refers to it as more amusing than credible. The problem is that the Second Circuit case that he's talking about was talking about a trial court finding, and that was a bench trial. It wasn't at the summary judgment stage where somebody took a view of two factual statements by each party and then determined that one was credible and one wasn't. For example, as to the point of knowledge and safe harbor, Judge Floyd, knowledge of Pru's trademark, it's undisputed in this case that Prudential doesn't use the name Prudential for the 1.3 billion people that live in China. They use another name. They can't use Prudential there because there's another pru.com. Maybe a jury would hear that and decide, well, Mr. Zhang Shenzhen, we don't really, but we believe that everybody should know about the big American company that operates in most places around the world. Or maybe a jury would hear that and say, wait, there's another company that goes by Pru in China? That seems like it might be plausible that somebody who registers a domain name from China where Prudential does not use the trademark Pru would have a good faith argument that they operated out of good faith. One of the problems with Judge Ellis's recounting in the court below, instead of saying Judge Ellis, the court below's approach to the factors is a lot of those factors finding bad faith are dependent on finding that a re-registration is a registration. So you're starting from the default position of saying that somebody created a domain name knowing that they were in conflict with existing trademark. That's the whole purpose of the Anti-Cyber Squatting Act. We're not saying that cyber squatters should be protected or that trademark owners shouldn't have recourse to the courts. We're simply saying that the real purpose of the act is to protect trademark owners from people who see distinctive marks and go out and create domain names for those marks before the trademark owner can do so, and then hold those marks ransom for a huge payday. That's not what we're talking about with re-registration, because in the case of re-registration, there's already been a domain name existing. All we're asking is that you balance the interests of people who created property rights in a domain name.
But before your time runs out, could you respond to the argument about waiver of the in rem jurisdictional issue?
In rem jurisdiction, it was a consolidated brief, a consolidated opening brief. The dismissal of Mr. Zhang out of that consolidated brief doesn't erase the issue that the issue that was on appeal was the improper exercise of in rem jurisdiction over the domain name. Mr. Zhang, if there were other parts of the appeal that dealt with relief that Mr. Zhang individually was seeking, well, then those might be arguments that were waived by Mr. Zhang. But the in rem part of that argument deals with the court's jurisdiction over the domain name, which was no one disputes, was still a part of the case after Mr. Zhang left. One thing that I would like to point out, try to point out as quick as I can, my colleague mentioned GoDaddy in Arizona. My colleague knows that by registering with GoDaddy in Arizona, that the GoDaddy terms and conditions require parties to consent to jurisdiction in Arizona of disputes with third parties regarding those domain names. As you look at the in rem issue, I would like to direct the court to look at the complaint itself, where Prudential first asserts that in rem is possible. Prudential says on April 22nd, 2020, that they had received a bad email address. They'd gotten a bounce back, and that they may not be able to exercise personal jurisdiction. Not upon information and belief, we will not be able to exercise personal jurisdiction over anybody. We may not. One thing they didn't say in that initial complaint is that a month before, they had gotten Mr. Zhang's information. They had his correct email, that both parties had been engaged in Arizona in the UDRP proceeding out there. They had every reason to believe when they filed their complaint that Mr. Zhang was not an unknown foreign person that was out of the picture. And all that was left for them was to try to exercise jurisdiction over the domain name. They knew that Mr. Zhang existed, that he was contesting the challenge of the transfer of the domain name, and that he had been subject to Arizona action over that matter. Either way, the in rem part of the Anti-Cyber Squatting Act talks about if the court decides that personal jurisdiction was not available. The court deciding means that that issue has been put before the court. The court below's decision on the motion to dismiss, it's wrong. Equating in rem jurisdiction to diversity jurisdiction is wrong. Diversity jurisdiction is a tool where all we are concerned with is the location of parties on the date that an action is filed. To equate that with in rem jurisdiction over a piece of property, we're not talking about the same animal. What we're talking about when we're talking about in rem jurisdiction is people's substantive rights and due process that is the only recourse someone has to address the situation to file an in rem action over the domain name because no one else is available. Is it that? Or do we have a person who from the outset is waving his hand saying, here I am the registrant, I consent to jurisdiction in Arizona. Prudential cites the Porsche decision, the Porsche
Mr.
decision.
Harlow, you're 2 minutes over your time, so I need you to wrap up.
All I was going to say is that we're a far cry in this case. When you make a responsive pleading and consent to jurisdiction, that's a far cry from somebody 3 days before trial throwing consent to personal jurisdiction in to just throw the whole thing out of whack. And I really appreciate the court's time. Thank you, Your Honors.
Thank you, Mr. Harlow. I want to thank both counsel for their arguments, and again, we'd love to come down and greet you, but we can't given the circumstances, but certainly do appreciate that you're being here today. With that, the court will stand adjourned until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.